Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about the LSAT. Cases that should have gone to the Supreme Court of Canada, but didn't. Alicia Yashishin applied to law school, but did not write the LSAT. In Canada, all law schools require that individuals who apply to the school write the LSAT, and usually they have a minimum score that has to be achieved in order to gain admission. Ms. Yashishin argued that the law schools were discriminating against her by refusing to consider her application without the LSAT score on the basis of the fact that she had a disability that prevented her from writing the LSAT or achieving a good grade on it. Ms. Yashishin argued that as a result of her disability, she was being discriminated against in the application process. She lost her case. This case raises important issues about what happens to people who have disabilities or for other reasons are not appropriate candidates to write the LSAT. For example, some disabilities can be accommodated, but others might not be able to be accommodated. We also know, when we look at the role of standardized testing, that standardized testing really only measures skills that are developed in the dominant culture. People from other cultural backgrounds, people from other walks of life might have different skill sets that make them perfectly suitable to be lawyers, but can't culturally perform as well on the LSAT. It is a discriminatory test, as is all standardized testing. And the LSAT itself is a completely outdated method of assessing whether or not a person is going to be a good lawyer. There is no study that has shown that an LSAT score corresponds to success in law school or success in the legal profession. And so, why is the LSAT necessary? This was an important opportunity for the Supreme Court of Canada, dealt with by people who all have written the LSAT, who all understand the process of going through law school, to look critically at what forced them into that position, what steps and hurdles they had to overcome, and whether those are actually necessary for people who want to become lawyers. Can there not be a better method of assessing whether or not somebody is capable of completing the requirements of law school? And if there is, then why are we continuing with these outdated methods? The Supreme Court of Canada could have used this as an opportunity to really assess the way in which we test the future members of the legal profession and the way in which we use culturally insensitive and discriminatory methods as a bar to entry, which would, of course, then have the trickle-down effect of correcting some of the over-representation of people in the justice system as participants and not as workers from these different backgrounds. We would see more Indigenous lawyers. We would see more lawyers with disabilities. We would see more lawyers from different cultural backgrounds, potentially, if the Supreme Court of Canada had taken the opportunity to take a critical, hard examination at why the LSAT is even necessary and whether there should not be accommodations of removing the LSAT in some instances. This is a disappointing move from the Supreme Court of Canada, and hopefully in another instance they'll have the opportunity to hear about the LSAT and why, in my opinion, and in the opinion of many other people, it is not a useful evaluator of whether somebody is suitable to ultimately become a lawyer. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Please like, subscribe, and share with your friends.